An explosive new 8-1 emergency order from the Supreme Court just dropped, and it completely changes the entire Second Amendment preservation fight forever. This massive decision flew completely under the radar this week, but it creates an immediate shift that could hit you next. If you think your right to carry, transport, or even purchase a firearm is safe just because of your state laws, the rules of the game just changed completely. This is not some distant legal theory debated by lawyers in a quiet room. It is a high-stakes ruling that alters how your constitutional rights are protected in real time. Many people are already getting the story completely wrong, believing the media headlines that only tell half the truth about what the justices actually did. We are looking directly at an emergency application decided by the highest court in the land, and the real-world danger for ordinary citizens is something you need to understand right now. Imagine driving across a county line or a state border on a normal family trip thinking you are completely legal, only to find out a brand new federal restriction has instantly turned your everyday carry setup into a serious criminal offense. Picture yourself at a local gun shop trying to buy a standard home defense tool, only to be turned away, because a sudden emergency order overnight shifted the legal definition of what is allowed. That is the exact kind of confusion and personal risk that is heading toward millions of law-abiding Americans who are not paying attention to the courts. In this breakdown, we are going to unpack exactly what happened with this 8-1 Supreme Court emergency order, what it really means for your safety, the massive trap most people are missing, and how this will trigger the next wave of local police enforcement. If you want to keep yourself, your family, and your property safe from sudden legal traps, you cannot afford to look away from what is happening right now. If you care about your constitutional rights and want the absolute truth without the mainstream political spin, take a second to hit the subscribe button right now so you never miss these critical updates. To truly understand why this 8-1 emergency order is sending shockwaves through the country, we have to look at how these fast-moving court battles actually work. Usually, when a major gun law is challenged, the case takes years to move up through the lower federal courts before it ever reaches the Supreme Court. But when a state or the federal government passes an aggressive new restriction, gun rights groups often ask for an immediate freeze on that law while the trial plays out. This freeze is known in the legal world as a preliminary injunction, which is just a fancy way of saying a court orders the government to stop enforcing a rule temporarily because it is likely unconstitutional. When a lower court either grants or denies that freeze, the losing side can rush straight to the Supreme Court on what is called the emergency docket, begging the justices to step in before the final trial even starts. That is exactly what happened here, and the lopsided 8-1 vote count shows that the Supreme Court is taking a very specific, aggressive stance on how these emergency requests are handled moving forward. The court decided to issue an emergency order that alters whether a controversial gun restriction can stay active while the lower courts continue to argue over the fine print. What makes this so critical is what the court actually did versus what it did not do, because the headline you see online might make you think the whole fight is completely over. The court did not issue a final, permanent ruling on the Second Amendment itself, meaning they did not strike down every single gun restriction nationwide with a single stroke of a pen. Instead, they ruled on the mechanism of enforcement, deciding whether the government can legally enforce a restrictive policy against you while the constitutional debate drags on for months or years. This distinction is exactly where ordinary people are getting completely confused, because a lot of gun owners think an emergency order means they are completely safe to go back to business as usual. It is like a referee blowing a whistle during a football game to review a play. The game has paused, but the final score has not been decided yet, and if you start running off the field early, you are going to get penalized. If you listen to the talking heads on television, they will tell you this is either a total victory or a total defeat for gun rights, but both sides are missing the deeper structural shift. This 8-1 order tells us exactly how the justices view the urgency of Second Amendment protections when state governments try to rush new bans into effect before the courts can stop them. It sets a massive precedent, which means a prior legal decision that forces lower courts to follow a specific rule, making it much harder for anti-gun states to use delay tactics to keep unconstitutional laws on the books. Now that the initial shock of this 8-1 order is settling down, the real debate is just starting to heat up in communities all across America. Do you think the Supreme Court should use these emergency orders more often to instantly block strict gun laws, or should they let the lower courts take their time? Drop a comment down below with your exact thoughts on this ruling, and make sure to hit the like button if you believe our Second Amendment rights deserve immediate protection without any delays. Here is what this means for you, and this is the exact moment where the legal reality turns into practical consequences for your daily life. If you are a first-time gun owner who just bought a firearm for home defense, a concealed carrier who carries a pistol every day to protect your kids, or someone who simply stores a rifle in the closet, this order impacts your legal risk starting today. When the Supreme Court issues an emergency order regarding firearms, it instantly alters the instructions given to federal prosecutors, state police, and local sheriff departments regarding what they can and cannot enforce. This means the legal ground under your feet is moving fast, and an assumption you made last week about your local laws could lead to an unexpected disaster if you're not paying close attention. It is your personal responsibility to know the exact status of your rights, because claiming you did not hear about a Supreme Court order will not stop a local prosecutor from bringing charges against you. Let us look at a realistic scenario that shows how this confusion plays out during a normal day for an ordinary citizen who is just trying to do the right thing. Imagine a concealed carry permit holder named Marcus, who lives in a suburban neighborhood and regularly commutes into a nearby city for his job or to run errands. Marcus bought his handgun legally, took the required safety classes, and has carried his firearm safely for over 5 years without a single negative interaction with law enforcement. Under the old understanding of the law, Marcus assumed that as long as his permit was valid and he kept his firearm concealed, he was completely protected from any sudden criminal liability while driving. But under the new environment created by these rapid emergency orders and shifting state responses, Marcus could easily fall into a terrifying legal trap during a routine traffic stop. Imagine Marcus gets pulled over for a broken taillight or a minor speeding violation, and he responsibly informs the police officer that he has a legal firearm in the vehicle, just like he was trained to do. If his state legislature recently passed a restriction that was briefly blocked by a lower court, but then altered by a Supreme Court emergency order that morning, the officer might have brand new instructions on what is considered contraband. A safer behavior for Marcus in this situation is to check the specific updated transportation and carry rules every single week, keeping a physical copy of his permit and any active court stays in his glove box. A much riskier behavior is assuming that because his setup was legal when he left his house on Monday, it must still be completely legal on Thursday afternoon. When the Supreme Court uses its emergency docket, the legal reality can change in an hour, and the officer standing on the side of the road is bound by the exact policy active at that precise moment. Consider another everyday scenario involving a homeowner named Sarah, who keeps a standard semi-automatic rifle locked in a secure safe for personal protection and home defense. Sarah does not carry her rifle in public, does not take it to political rallies, and only uses it at a local firing range a few times a year to maintain her proficiency. She hears about a new state law banning certain common firearm attachments or mag capacities, but she also hears a headline saying the Supreme Court issued an emergency order changing the fight. If Sarah assumes the headline means her specific rifle is completely grandfathered or permanently protected, she might decide to order replacement parts or accessories online without looking at the fine print. The risk here is that if the emergency order did not completely strike down the state law, but instead sent it back to a lower appeals court for review, the state's restrictions might still technically apply to new purchases or shipments. A safer behavior for Sarah is to pause any firearm modifications or online parts orders until the formal mandate from the court is officially integrated into commercial shipping guidelines. A riskier behavior is trying to rush an order through a website, assuming that a Supreme Court headline acts like a universal shield against local state regulations. If the package gets intercepted or flagged by a compliance system because the state law is still technically active during the appeal, Sarah could face an unexpected investigation for violating a local restriction. The timeline of a court battle does not care about your convenience, and a misunderstanding about an emergency stay can turn a peaceful homeowner into a legal target overnight. Let us look at a third scenario involving a young veteran named David who decides to travel across the state line to attend a competitive shooting match or a hunting trip with his old friends. David checked the federal interstate transport laws, which usually protect travelers who keep their firearms unloaded and locked in the trunk of the car, separate from the ammunition. However, if the state he is traveling through just had a massive gun law reinstated or blocked by an 8-to-1 emergency order, the local state police might be conducting heightened enforcement checks along major highways. If David gets stopped and his vehicle is searched, a misunderstanding about whether the Supreme Court blocked the whole law or just a small portion of it could lead to his property being seized. Safer behavior for David means mapping out his entire route, avoiding states with active legal chaos entirely, or calling a local attorney in the destination state to confirm the exact status of out-of-state travelers that week. Riskier behavior is relying on general online forums or social media posts where people are loudly celebrating a court win without reading the actual legal text of the order. The Supreme Court might have saved a gun right in theory, but if the local state troopers are still operating under an old enforcement directive, you could spend thousands of dollars in bail money just to prove you were right in front of a judge weeks later. You have to separate the ultimate constitutional victory from the immediate practical danger of being the test case for a confused law enforcement agency. Here's where the situation gets much larger, and this is the absolute core of the story that the media is completely hiding from the public right now. The real battlefield is not just about the specific firearm or accessory named in the lawsuit. It is about who holds the ultimate power to control your daily behavior while a law is being tested. If you want to protect your home, keep your family informed, and stay ahead of these hidden legal traps, hit the subscribe button right now because the next few months are going to be chaotic. Think of this entire situation like a massive tug of war between aggressive state lawmakers who want to restrict your rights and a Supreme Court that is trying to keep the Constitution intact. When a state passes a law that clearly violates a previous Supreme Court precedent, they are essentially daring the federal courts to come out and stop them, knowing the legal process moves incredibly slow. This is like a rogue landlord changing the locks on your apartment while you are at work, forcing you to go to court for months just to get back inside your own home while they suffer zero consequences. The 8-to-1 emergency order is a direct response to this strategy, showing that the highest court is losing patience with states that try to use bureaucratic delays to suppress constitutional freedoms. This is where the next massive fight starts, because anti-gun politicians are already looking for ways to bypass this emergency order by writing new, slightly different laws to restart the clock. The bigger issue that most people still do not see is how this fractures the United States into a confusing patchwork of free zones and restricted zones where the rules flip back and forth constantly. This is like driving down a highway where the speed limit changes from 60 miles per hour to 10 miles per hour every single mile without any clear signage on the road. In one county, your standard capacity magazine is a protected tool of self-defense. But the second you cross an invisible line into the next county, that exact same piece of plastic is treated like a dangerous felony device. This level of confusion is not an accident. It is a deliberate tactic designed to make everyday citizens so terrified of making a mistake that they choose to leave their firearms at home or give up carrying entirely. The Supreme Court's emergency order is an attempt to inject some sanity into this chaos, but the immediate result is a massive wave of panic from state governments rushing to defend their restrictive agendas. Let us bust 3 major myths that are spreading like wildfire across social media comment sections and gun range chats regarding this 8-to-1 emergency ruling. The first big myth is that because 8 justices signed off on this emergency order, the Second Amendment is now permanently safe from any future bans or restrictions across all 50 states. This take is completely wrong and highly dangerous, because an emergency order on a specific application is not the same thing as a final, permanent judgment on a full constitutional case. The court was deciding a temporary issue of enforcement, meaning they were setting the rules for the legal battle, not declaring a final winner for every single future dispute. Believing this myth will make you complacent, leading you to ignore local state bills that could easily pass next month and create a whole new set of legal headaches for your household. The second massive myth is that local police officers and county sheriffs will immediately stop enforcing state-level gun restrictions the moment a Supreme Court order is published on the internet. In the real world, police departments operate under a strict chain of command, taking their direct orders from local police chiefs, city councils, and state attorneys general, not from a live feed of court opinions. If a state attorney general tells his officers to keep enforcing a law despite a Supreme Court emergency stay, those officers are going to follow their local directives until their department officially issues a new training memo. If you get caught up in an enforcement sweep, arguing with an officer on the street about a Supreme Court vote count will get you nowhere, and it can easily escalate a tense situation into something much worse. The proper place to fight a constitutional battle is in a courtroom with an attorney, not on the side of a highway during a stressful encounter with a confused officer. The third myth, that is causing an immense amount of trouble, is that this emergency order automatically clears the record or drops charges for anyone currently facing a gun-related trial in a lower court. Many people believe that when the highest court issues a strong ruling, it acts like a universal undo button for every ongoing criminal case involving firearms across the entire United States. The reality is that our legal system is built on a slow concept called standing, which means a court order only directly applies to the specific people, organizations, or jurisdictions named in that exact lawsuit. If you are facing a local charge under a separate statute, your defense attorney can certainly use this Supreme Court order as a powerful weapon to argue your case, but it does not happen automatically without a lot of expensive legal work. You cannot let your guard down based on a headline, because the system will gladly use your lack of specific legal knowledge to trap you in a long, painful prosecution. Look at how the lower federal appeals courts and state legislatures are already reacting to this 8-1 decision, and you will see exactly why this fight is nowhere near finished. Several anti-gun governors have already called emergency legislative sessions to draft workarounds, trying to find loopholes in the Supreme Court's order before the ink is even dry on the paper. They are trying to reclassify where you can carry a gun by declaring almost every square inch of their states to be a sensitive place, including public parks, sidewalks, and private businesses. This means that even if the Supreme Court says you have a right to carry a firearm, the state makes it practically impossible to step outside your front door without violating a local zoning rule. This is a direct challenge to the authority of the highest court, and it ensures that the legal terrain will remain incredibly unstable for the foreseeable future. This is exactly why maintaining a grounded, responsible mindset is so vital for the protection and dignity of your entire family. When you see a massive legal update like this 8-1 emergency order, You have to look past the instant emotional reactions of online influencers who are just looking for views and clicks. You need to ask yourself the practical questions. Has my specific state attorney general issued a response to this order? Has my local sheriff changed their enforcement policy? And does this alter my travel plans for the next few months? Being an informed gun owner means understanding that your freedom depends just as much on your legal awareness as it does on your firearm safety habits. The law is a powerful tool, but if you do not know how to handle it properly, it can easily be turned against you by people who want to remove your ability to protect yourself. As we look closely at what is coming down the road, this emergency order is going to force a massive showdown in the lower federal courts over the next few weeks. Judges who have been intentionally delaying Second Amendment cases for years are suddenly facing a Supreme Court that is willing to step in and override them with a decisive 8-1 majority. This means the bottleneck of blocked gun cases is about to break wide open, causing a flood of rapid decisions on assault weapon bans, magazine limits, and concealed carry restrictions all at once. For the everyday citizen, this means the news cycle is going to move faster than ever before, with laws being active one day, blocked the next, and reinstated the week after. It is going to take an immense amount of discipline and careful attention to navigate this environment without making a critical mistake that could destroy your future. To bring everything back down to a clear, solid foundation, there are 3 absolute takeaways you must remember from this historic 8-1 Supreme Court emergency order today. First, the highest court has sent a clear message that it will step in to protect constitutional rights from aggressive state overreach before a full trial even finishes, breaking the old delay tactics used by anti-gun politicians. Second, this emergency order does not mean every local gun restriction is instantly gone, and you must check your specific state and county policies every single week to avoid hidden traps during transport or carry. Third, the legal landscape is going to experience an unprecedented wave of fast-moving changes as lower courts are forced to fall in line, meaning your knowledge must remain sharp and up to date. Understanding these 3 rules is part of being a prepared, responsible defender of your home, ensuring that you never let political confusion compromise your family's safety. We are building a dedicated community of independent, serious Americans who refuse to be kept in the dark by misleading news coverage and complicated legal jargon. If you want to stay ahead of the curve, protect your constitutional rights, and get the honest truth without the games, make sure you subscribe to the channel and join our community right now. Drop a comment below letting everyone know how your local community or gun stores are reacting to these fast-moving court decisions this week. Stay alert, keep your head on a swivel, protect the people you love, and I will see you right here in the very next breakdown.